Right, so I'm just going to do another quick video now to complement the last one, which sort of show the timescale reasons why those Parliamentary Privileges Acts were enacted. And none of them were supposed to remove the rights of a MP to perform their duty for the electors without any intervention against their personal body or work until the end of Parliament sessions. But proceedings could commence in courts of records, but not in the petty sessions until the end outside of Parliament session time. So here, I put here in massive letters, must be a court of record. That's what the Act says. And this is when we're talking about felony, because felonies were dealt with in courts of record. And when we said we abolished the felony, it said that anything that was previously a felony was reduced to a misdemeanor, which does not mean that where it says felony in any acts or anything that it could be proceeded against. It meant that it would be treated as in what previously felonies were treated as, right? Must be a court of record. Only court of record can hear the case, right? And if you start in a magistrate's court, the first initial proceedings aren't on court of record, right? Now, this really, I know that they've been doing it wrong anyway, and they don't even care about this point because they've been prosecuting people like Suella Braverman with driving offences, right? Driving offence is only a summary driving offence. So, like, it's a no-brainer. Magistrates' court is not properly a court of record, right? It isn't, and it never meant it to be. It was, magistrates' court is meant to be the petty sessions or hundreds court. So, so they're talking about must be a court of record. What does that mean? It means they meant quarter sessions, assizes, or the High Court. That's what they meant. When they rated the words, it has to be a court of record. When they enacted it, what does it mean? They mean it has to be quarter sessions, assizes, or the High Court, right? And not petty sessions, right? Not petty sessions, because the petty sessions, like I said in the other video, are on all the time, and you can go to them and have things sorted out in between the Parliament sessions, right? Quite easily. But the court of record, quarter sessions are only 4 times a year, and assizes started off twice a year. So that these are like periodicals, and they're not convenient. And this is to do with, like, the whole Act is called Inconveniences with Privileges of Parliament, right? So in between the Parliament, when there is no Parliament, you might not have a quarter sessions, you might not fit in with it. So this is the thing. Now, this video, this one, is about these either way offences, right? Either way. So it can either be summary, right, which that's petty sessions. A summary offence or an indictment. Indictment is court of record. But from what I've read, this is the thing that I want to point out now, right? I don't know if I can colour code this or not. So, I don't know what colour to use, maybe grey, right? So, look, so the petty sessions, right? So if that grey line at the bottom is the petty sessions, okay? The petty sessions only heard trivial matters, which is the equivalent of Suella Braverman's driving offence, right? But from what I've read, okay, the petty sessions could refer some civil cases to the quarter sessions, right? Because quarter sessions could hear civil cases. So if someone appealed something from the petty sessions in a civil matter, or they wanted to have a jury or something like that, right? It will go to the quarter sessions from the petty sessions, okay? So I put this arrow here. So there's a blue arrow there, right? So from the petty sessions, they can refer a case to the quarter sessions. This is from what I've read, right? So that is starting in the petty sessions. But from what I've read, right? I'll choose purple now. The quarter sessions is where you had to hear a criminal case and it got referred, and if it was it got then put to the assizes because you had like the Gale, right? So from the quarter sessions to refer criminal cases to the assizes, right? But from what I've read, they did not start serious criminal cases in the petty sessions, right? From what I've read, they did not start them in the petty sessions. They started them, from what I've read, in the quarter sessions, and then they heard the case, and they went to the assizes. That is a court of record to court of record, right? So if it's an indictment, it's never in petty sessions, from what I've read. But the petty sessions could hear the normal everyday cases which did not start as serious cases, but may escalate or appeal up to the quarter sessions so they could get heard by a jury or judge, and then it might go to the High Court, right? But no very, very serious criminal offence started in the petty sessions, right? This is why they had to wait until quarter sessions come along, and then you've got the Gale and so forth and the assizes. So for these cases that we've got now either way, if it was summary, then it would be dealt with petty sessions, right? But if it was not summary, or the equivalent of it, if it was an indictment or felony, then it wouldn't ever be in the petty sessions. They waited until quarter sessions come round, and then to assizes. So it's always been dealt with properly by a court of record, because part of the proceedings wouldn't be court of record, would they? Because the magistrate's court isn't a court of record. So I think that these either way cases have messed it up with parliamentary privilege. Now, I might be wrong about this, don't get me wrong. I could be wrong about this, but I've done the research, and I don't think that you can have a hearing, a trial, a first hearing or trial in a court which is not a court of record, like a magistrate's court, because it is only the equivalent of the petty sessions. It's only the equivalent of the petty sessions. This here, this petty sessions here at the bottom, the petty sessions, hundreds court, you cannot. It says that it cannot be that court. Can't be it. So how you have these either way cases in there for privilege? I don't think that you can. Now this only really affects MPs, because this doesn't affect the average citizen who's being charged of an either way offence. It's peculiar to MPs and peculiar to parliamentary privilege. It doesn't really affect normal citizens, because either way offences don't usually involve privilege, so it's only for MPs. So this is a particular anomaly. Now, if I'm wrong, if they did hear serious offences in the petty sessions, but I don't think that they did, because from what I've been reading in the actual petitions themselves, I mean, I've been reading some of the petition archives, and, you know, usually when they were put under arrest, they would have to wait. You see, I've got a writ of privilege from George Cook, the Sheriff of Yorkshire, and someone prosecuted Tillotson for trespass, right? And he's attaching the privileges of Westminster Hall. So this is one of those Westminster Hall trials. I don't think that the defendant had to turn up. I think that I've read some legislation where the defendant could arrange for the council to represent them in Westminster Hall. While they were obviously, like, they might have been in Yorkshire under detention, but it was under the authority of Westminster Hall, right? They didn't necessarily have to go to London if they could get someone to represent them there, defend them there, right? So what I've found is, with that case, the Sheriff of Yorkshire writes out a warrant for Tillotson, two persons, for their arrest, and they're going to get arrested and tried at Westminster, right? And they're going to have to wait until that trial date, okay? But it's not heard in the petty sessions. They don't hear it in the petty sessions because the petty sessions don't have jurisdiction over it, because it was a Westminster Hall trial. So, I mean, I think that it was being... I think they went to the sheriff and got the writ, and then it was just straight into Westminster Hall. I don't think that they heard that in the Court of Sessions, because he's attaching the jurisdiction of Westminster Hall. If I'm wrong, I'm wrong. So these either way cases, what they've started referring from the Magistrates' Court to the Crown Court, I only really think that they start... You see, I don't think those either way cases existed at the time these Privileges Acts were made. All these either way cases we've got now are something of a modern thing. It's like a modern creation, a modern invention. All these either way cases where it can be an indictment or this. It seems like they're messing people around, because like with my driving offence, you know, it could be either way. But what they did is, after they took longer than the time, if it's summary, they've got so long to do it, right? They've got a certain amount of time, right? And if they don't do it within that time, but because it was an indictment, they could have longer time. So they messed around, they took absolutely ages, and then they didn't even bother making an indictment. So, and then they asked me if what I wanted it to be. It's not like, oh, we're going to indict you or we're going to summary you, and then, you know, therefore, you know, we can do this. After they'd spent longer than the time allowed for summary, then they said, oh, well, we're just going to keep it summary. So they actually ended up using the amount of time for an indictment, but then they decided to summary, and then the judge asked me, do you want it to be summary or an indictment? Well, I said, well, summary. I wish I'd have actually asked for an indictment, because from what I know now about juries and rights and so forth, but I got to choose, and I chose the one summary which actually rendered that, you know, summary are meant to be dealt with in a certain amount of time. So they actually, the police ended up with a summary prosecution getting to use the amount of time that would normally have for an indictment. So I think that this either way is a route. The police are toying with time. It's like, hey, we can take all the time we want about summary charges now. You know, we can take, 3 years and then just put someone through a summary charge, right? It's giving them the ability to just do what the hell they want, right? So, I mean, I don't like it, but when it comes to privileges, it says that it must be a court of record. So, at whatever point, what am I doing in a magistrate's court? What am I doing in this magistrate's court? Is this a court of record? No, right? Well, this is illegal then, surely. Well, no, but this is an indictment. Well, if it's an indictment, why am I stood in a court of record? Oh, because they have to start the magistrate's court. Since when? Well, since we abolished the assizes and quarter sessions, in the 1970s. Well, that's not that long ago, is it? It's about as old as one person now. So, and there haven't really been that many changes to privileges in the law since then. So there are a few peculiar anomalies, but, I don't really think it matters too much about that, because I know that with Suella Braverman, they just did it anyway, even though it was blatantly summary offence and blatantly not dealt with in a court of record. And that's where I am with it. So there's two things. I've researched it. I haven't meticulously researched the quarter sessions to assizes, but I read enough. I read a few websites that said indictment started off at the quarter sessions and then they might have sent it to the assizes. They're both courts of record. I did not read anywhere that the petty sessions dealt with serious crimes and sent them to assizes. It said that minor issues are dealt with by the petty sessions, and if you decide to appeal it or raise the matter, like writ of error or something like that, then it gets sent to like the quarter sessions, right? But obviously it started as a petty matter and someone appealed it or chose it to go higher, right? And the way they're doing it now seems to be that they're always starting it as a petty matter. What if you don't want to raise it? Well, then it's never a serious matter. I don't like this either way situation. When it comes to parliamentary privileges, I think that either way thing is an issue, and it's an issue only to MPs and members of the Lords. It's not really an issue to anyone else, but it's actually created a bit of a very peculiar niche in the way that since the 1970s, when they abolished the quarter sessions and the assizes, the way that these serious offences are being dealt with and proceeded in, and we know that the Crown Prosecution Service since 1985 has not been properly acknowledging privileges because they don't want to ever be in contempt. They don't want any of their members of staff to have committed contempt or be liable to contempt, so they just refuse to acknowledge it. So that's where I am with it. From what I've read, if you look into it, these serious indictments were court of record was not petty sessions. Petty sessions is always small issues that grow into a bigger issue if someone wants to appeal or pursue it. If it's a serious matter, it would start in a serious court, which you had your quarter sessions,